We present to you Group 6, a role play.
Welcome. Please have a seat. Have a seat. Okay, so good afternoon to all parties. So, and welcome to this mediation session. My name is AMGENERAL and I will be your mediator for today. Okay. So first of all, thank you so much for being here and for choosing mediation as your way to resolve the issue that you're facing. Okay. So it's like this mediation is like a step to show your willingness in working together to find a solution in your issue. So before we start our session, I would like to introduce myself. My name is AMGENERAL and you can call me Miss Aisha. So today I will be your mediator into this session. So let me tell you briefly about my qualification. I am a very well-trained and accredited mediator for like 2 years of experience until now in resolving disputes over across the states of Negeri Sembilan. So for now, may we have each of the parties introduce yourself, or maybe how would you like to be addressed as? Either of you can start.
Okay, I would like to start first. Hi, good evening. My name is Zafira, just call me Zaf. I'm the construction manager of DKLS Construction Civil Berhad Company.
Okay, how about you?
Hi, good evening. I am Ms. Farhana as the negotiator of AMGENERAL Insurance India Berhad Company.
Alright, that's good. Okay, so now, before we proceed with this session, I will explain first on how this mediation is for you to get a clear picture about what this process is all about, right? So mediation, first of all, mediation is like a voluntary and confidential method of resolving disputes where both parties, which is both of you, are involved in working together to reach a mutually acceptable solution and agreement, assisted by me as your mediator, and also I'm the neutral third party. I'm known as the neutral third party. So this means that I will act as your mediator, but bear in mind that I do not impose any decisions on both of you, right? But instead, I will facilitate the communication and the negotiation between both of the parties, which is both of you, in order to achieve the best compromise and the best reconciliation that we can get. Alright? Okay, so mediation also is often used as an alternative court proceeding, which we can call it as out of court settlement that can save time, reduce costs, and also preserve the relationship between both parties. So just bear in mind that this mediation session is voluntary and confidential. So this means that everything that we discuss in this room will stay between us. So unless both of you agree otherwise, or it was as required by law, right? So as your mediator, my role is to remain neutral and impartial. So I am not here to take any sides or give legal advice or even make decisions on both of you, right? So this process is entirely voluntary, as I mentioned before, which means both of you are free to decide whether or not to reach an agreement or settlement. Okay, so the power to resolve this issue rests and depends on both of you. Okay, besides my role here is just to act as a neutral person, so I have no power to force a decisions on you or to decide how this matter should end or to be settled. So throughout this process, if either of you think or feels at any stage that I am not being neutral or I do have some kind of like bias or something, so please let me know, okay? So up until now, are you guys okay and can still follow me? Yes. Okay.
I'm also good.
Alright, good. So to ensure that today's session is productive and respectful, we will follow a few ground rules. First and foremost is only one person speaks at one time. Okay, so this can ensure for us to have everyone is to be heard. Alright. So secondly is to respect each other's views, even if you do not agree with them. Okay. this session can also maintain the continuity of the session. So last but not least, we do observe common courtesy in which how we address and how we respond to this issue to one another. Okay, so do you both, up until now, do you both understand these ground rules, or do you have any concerns or any questions regarding this before we move forward? Before I forgot, let's review the mediation agreement. Has it been signed by both parties? If not, we can take a moment to go over it together to ensure you both understand the terms and conditions and we are comfortable signing it before we begin.
I've signed it, but I have a few questions. May I know whether the mediation agreement legally binding?
Oh, that's a really great question. So the mediation agreement itself is not legally binding. It is more like an understanding for all of us about how this process will be conducted. But however, if we reach a settlement during the mediation, that agreement can be made legally binding if only you both agree to it.
Okay, so if I feel like this process is not working, can we stop at any time?
Oh yes, absolutely. Mediation is entirely voluntary. So either of you can choose to stop at any point, at any time. If you feel it's not helping, if you feel like this mediation session is not helping you anymore, or you feel like you're uncomfortable, so we will respect that decision.
Okay. Also, if we sign an agreement during the mediation, does that mean we will definitely reach the settlement?
Oh, not necessarily and not always. Signing the mediation agreement simply means that you agree to participate in good faith and follow ground rules that we have set. So a settlement depends on both of you in order to working together to find a resolution.
If we do reach a settlement, can that be used in court?
Oh, the discussions we have here are confidential and cannot be used as evidence in court. But however, if both of you agree on a final settlement and put it in writing, that document can be presented in court if necessary.
I have one last question. Can we renegotiate the terms during this process if something changes?
Oh yes, of course. Mediation is flexible. It's very flexible. If new concerns or issues coming up, we can adjust the address and address them during the process. So it is important that we work together to meet everyone's need. So that is all. Do you have any questions or concerns before we proceed?
For now, I'm clear.
Okay, thank you so much for the question. At least I know we are on the right track. Okay. So now I need to confirm how long each of you are available for today's session, just to manage our time respectively.
For me, I will be free for only 2 hours, so I hope that we could settle within that time. How about you?
Yes, I also can make time for that.
Alright, okay. Now that we have covered the ground rules and the process, what specific issues would you like to discuss? I would like to know further on how this dispute began. Who would like to start first? Either of you can start.
I would like to start first. Since I'm the one who suggests and initiates to bring this to mediation session, I'm the construction manager for this project, and it was a big project for 40 units of shop houses in Kedah. Since it was big, so I had purchased a contractor's or risk insurance policy from AMGENERAL insurance company. We have read all the policy and believe that the policy covered various risks during the construction period from 15 October 2009 until 31 August 2011, and the maintenance period from 1 September 2011 until 28 February 2013. It also included an extended maintenance clause, which is we call as EMC. But the problem is that when there is an issue within the
Miss Berhad company's negotiator, and I have been working for this insurance company for 6 years. Okay, so in our case today, we have issued a contractor's all-risk insurance policy to DKLS Constructions near Berhad and PKB Semarak Daya near Berhad for a construction project. So the policy covered 2 distinct periods, which is firstly, construction period from 15 October 2009 until 31st August 2011. And secondly, for the maintenance period from 1 September 2011 until 28 February 2013. Plus, an extended maintenance clause (EMC) was also included to address specific risks related to the maintenance obligations. However, the theft occurred was not covered in the EMC. In the policy, there was only an extended coverage for risks directly linked to maintenance operations.
Wait, Miss Farhana, but your company was our insurer, so you should have allowed us to claim the damages since we had paid the insurance. That's it.
Means of, at the first place, you should understand that the occurrence of theft during the maintenance period fell outside the scope of Clause 1 of Extended Maintenance Clause, which applied exclusively to the construction period. So it is beyond our liability and it is not our fault.
Okay, Miss Farhana, I understand both of your concern. Thank you so much for your participation so far. We believe that it would be beneficial for us to move into a caucus session. Okay, so this means that I will meet each of you privately for a short time, and this step will allow us to explore your concerns and your perspectives in greater depth and more in consider options more openly lah. So this purpose of the caucus session itself is to provide a safe and confidential space for you, both of you, to share information that you might not feel comfortable discussing in this joint session. So I want to assure you that anything you share with me during this caucus session will remain confidential unless you explicitly want me give me permission for me to disclose it to the other party. Okay, so this confidentiality is very critical to the process, so feel free. I hope both of you will feel free and be open throughout the session and be as I said before, as open as you need to be. Okay, regarding the duration for each caucus session, do any of you or do either of you have any suggestion on how long this session, this private caucus session will be conducted?
For me, I think 10 to 15 minutes will be fine.
Okay.
I also agree with the given time.
Alright, cool. So to begin with, we would who would like to start first? Either of you can start, Miss Zafira or Miss Farhana. And bear in mind that is the other party okay to wait for a little while in the lounge, and I will call you in shortly for your session.
So I would like to start this.
Okay. So before this, I would like to remind both of you that this session is confidential, and I will not tell anyone about what happened today in this room, and what stays here stays here. Okay? Alright. Okay, Ms. Zafira, you can start.
Thank you, Miss Aisha. Actually, Miss Aisha, I'm not satisfied with them for not willing to pay because I felt that the insurance price was quite high, especially in the construction industry. So I think that it is right for me to get the money, and I truly want the construction to be finished, as this will affect my company's review. This will reduce our reputation, as this is our first time for having this kind of problem. I just want to be known as a good company, but if they don't want to pay, what should I do?
Yeah, I understand your frustration. So, as we already discussed in joint discussion before, Miss Farhana mentioned about that the theft was not covered in the policy. So, Miss Zafira, what do you think about the terms and conditions in the policy itself?
Actually, Miss Aisha, the EMC was ambiguous for me. It is unclear or open to more than one reasonable interpretation.
Okay, I understand. I take note of that. So, from my understanding, you can correct me if I'm wrong. Your main concern here revolves around the ambiguity it should be interpreted. So can you help me understand a bit more the reason on why you believe it should be interpreted in your favor?
It is because the EMC is about what exactly is covered and for how long. Since it's not clear, we believe it should be read in a way that benefits us, the insured party. After all, the insurer drafted the clause and any unclear terms should be interpreted against them.
Okay, so here can you share an example on how this ambiguity has impacted your understandings and your, or you can say your expectations under the EMC itself?
The clause does not clearly state whether theft is covered under the maintenance period. The insurer argues that theft is not included, but the language is vague, and I think it's reasonable to interpret it as providing coverage. It is unfair that they are using their own unclear wording against me. I had to cover the losses out of pocket because the insurer denied the claim. It's been a financial strain, and I feel they are avoiding their responsibility by exploiting the vague language in the clause.
Okay, Ms. Safira, I truly understand your frustration here. Thank you so much for sharing that. It helps me understand more about your perspective. So I want to ask, what outcome would you consider fair in this situation?
Ideally, I had like the insurer and general insurance Berhad company to honor the claim and cover the theft under the maintenance period. If that's not possible, I want them to at least negotiate a settlement.
That's a reasonable position. So is there any flexibility in your stance if let's say the insurer proposes a partial resolution?
I'm open to discussing it, but it depends on the terms. I want to make sure it's fair and reflects the coverage I believe I had, that's all.
Okay, thank you so much for being open throughout this negotiation. So I'll take this information into account. And is there anything else you want me to keep in mind?
I think no, that's all.
Alright, thank you so much, Ms. Zafira. Now I will discuss this with Ms. Farhana, and maybe you can stick out for a while for me to discuss with Ms. Farhana.
Sure.
Okay, thank you, Ms. Zafira. Thank you so much. Please help me some. Ms. Farhana, please have a seat. Okay. Sorry to keep you waiting. Now, you can share with us what is on your mind. Is there something you would like to say that you cannot say in front of the other party before? But rest assured that this session is confidential between us, so you can express any feelings and any dissatisfaction that you have.
Okay. Firstly, I do agree that we are the insurance company. However, they should have recognized the danger of theft at the construction site and take sufficient precaution to prevent the theft. It is not all under us just because we are the insurance company. Do they think we have plenty of money just because they pay us? Huh. Hey, they only pay 1/4 from what they want to claim, okay? And we clearly state that theft was not covered under the policy. If they want to talk about breach of agreement, then we can say that they also breached the condition 3 of our agreement that requires them to take all reasonable precautions to prevent loss, damage, or liability.
I understand your frustration, but thank you so much for sharing your perspective here. It is clear that you have a strong feeling about this, and I appreciate your honesty. So let us first unpack some of these points to see how we might move forward. So you mentioned before that the theft wasn't covered under the policy. So could you clarify how that is communicated in the extended maintenance clauses itself?
The insurance coverage had expired when the theft occurred. So the EMC here was not ambiguous, and it was clear that it did not cover the theft, as the only risk it covered was the risk specifically mentioned therein. And it also excluded all the risks covered by clause 1.
Okay, and regarding the condition 3, you're saying that the other party didn't take sufficient precautions to prevent the theft. So can you Do you mind provide me the examples or an example of what you believe that they should have done?
Okay, the example is like securing the site properly with guards or advanced surveillance. They did not do that. They left it vulnerable and now they want us to pay for their negligence.
Yeah, understood. So it seems that your concern is not just about the ambiguity, but also about the accountability for the situation. So what outcome, I would like to ask, what outcome would you consider fair given these circumstances?
At most, I think we had considered a small settlement, but it is not fair for us to take full responsibility when they did not follow the agreement.
Alright, thank you so much for sharing your position. So I'll take this back to the other party and we'll see how it goes. So before we conclude, is there anything else you would like for me to address before we move to the next stage of the session?
Okay, I just want to make it clear that we are not a bottomless pit of money. They need to understand that insurance has limits and responsibilities on both sides.
Alright, thank you so much for your openness. I'll take your point into account as we move forward to the next stage, which we will have a joint negotiation between both the parties. Alright?
Okay, thank you, Ms. Aisha.
Okay, that's all. Thank you so much. Welcome again. Please have a seat. Alright. Alright, so Ms. Zafira and Ms. Farhana, since confidentiality is a cornerstone of our process, I am not at liberty to share what was discussed in our previous private session, unless both of you you choose to bring it up yourself. Alright. So with that being said, I would like to open the floor to either of you to share what you feel comfortable discussing from your private session that maybe could help us move forward.
So, I would like to start first. On behalf of DKLS Construction, we believe that extended maintenance clause (EMC) policy is ambiguous, and they argue that theft should be reasonably be covered under the EMC. We had to cover the losses of out of pocket, which has caused financial strain, and ideally, we want the insurer AMGENERAL insurance preferred company to honor the claim and cover the theft under the EMC. Alternatively, we are open to negotiating a fair settlement that reflects the coverage we believe we should have. So that's all.
Okay, from my side. However, on behalf of AMGENERAL Insurance, we believe that the EMC explicitly excludes theft and that the clause only covers defects or issues related to maintenance. We also want to emphasize that DKLS Construction has reached condition 3 of the policy, which requires them to take all reasonable precautions to prevent loss, damage, or liability, such as securing the site properly or set up a guard to keep the site safe. We are also frustrated that the other party is trying to shift all the responsibility onto us while neglecting their own duties. As far as I could think, we are willing to consider a small settlement, but we also believe we should not take full responsibility due to DKLS alleged negligence in securing the site.
Alright, thank you so much Ms. Zafira and Ms. Farhana for opening up. And I can see that each of the parties, each of you has their own alternative to settle this dispute. So both of you have brought forward well thought out alternatives, well done, and that's a great starting point. So now, the key question is how we can move closer to a resolution that consider both sides. So let's explore the benefits and challenges of each alternative altogether, right? So sometimes combining elements of both proposals and finding a middle ground that can lead to an outcome that works for everyone. So let's take a look at the alternative proposal that we considered. So I'd like to hear from both parties. Are there any aspects that either of you may find workable or worth if we explore it even further?
I would like to start first. Thank you, Ms. Aisha. While we appreciate your willingness, Ms. Farhana, to consider a small settlement, we believe there are
willing to pay only 1/4 from the claim you have made.
Sorry, Ms. Farhana, I agree with that proposition. Can you make it half of the damages?
Ms. Zov, we understand that DKLS construction feels the EMC is ambiguous. But as we have stated before, the clause was drafted to clearly cover only defects and maintenance-related issues, not the type. Our stance is based on the terms of the agreement. You also breached the agreement as you did not take any precautions. Can you see that it was also your fault? How can a construction site have no guard? The construction site is so spacious. You should have used your brand that theft would have occurred. As I think that it was both of our fault, we can settle this dispute with us paying only 1/4 of the claim.
We are willing to acknowledge that enhanced security measures could have mitigated the risk of theft, but we still need you, our insurer, to recognize the financial burden we have faced and offer a fair settlement. I have a new suggestions. What if we go to the middle? Can we make 1/3 from the claim? I will agree to incorporate if this will be part of the resolution.
That's a constructive step, Lisa. It is good if they're willing to acknowledge their part. Ms. Farhana, do you think this acknowledgement from Ms. Zafira would make you more open to consider a larger settlement amount?
I think that was okay and agreeable.
Okay, I'm glad to hear that. This proposal is agreeable to you. So it is encouraging to see both of the parties taking steps forward towards a resolution. So both of you have agreed to all the terms that both of you proposed to each other. So I would like to confirm again with both parties, is there anything else that you want to add or ask? Any of you?
Nothing to add. I can accept all these suggestions.
I think I am fine with the suggested solutions.
Alright, cool. I'm glad to hear that. Thank you for both of you for working together to find a mutual solution. So before we end this session, I would like to ask both of you, each of you, to sign this agreement as a proof to that a settlement has been reached. So in this agreement, we will have included all terms and conditions that we agreed today. So when you sign this agreement, you need to comply with all the conditions. So this applies to both of you, and in this event, either of you breach the contract and will breach any term and condition in this agreement, the aggrieved party may sue the defaulting party for breach of the agreement itself. So alright, so you may sign the agreement. Thank you so much.
On my part, Ms. Aisha, I just want to say thank you for guiding us as a mediator through this session today. And for Ms. Farhana, I would like to apologize to you for being harsh throughout this mediation process later. I'm looking forward for us to comply with the agreement this time.
Okay, thank you, Ms. Aisha, and also thank you so much, Ms. Zaf, for your cooperation and understanding. I am so sorry for any inconvenience behavior on my part, if any.
Okay, thank you once again, Ms. Zafira. Ms. Farhana, thank you so much for your tremendous effort and cooperation. That was a brilliant work. With that, we shall end our session. Thank you so much for your participation. Thank you so much.